We have heard and learned what ESG is, and now let's look into the S part of ESG, or social aspect. It is looking into the welfare of an organization's stakeholders to present its best practice on the social aspect of ESG. We have the International Container Terminal Services Incorporated, or ICTSI, a global port management company. And they will be talking on the lessons from landmark decisions about the environment and labor relations. Presenting this talk is an independent director of ICTSI and retired Chief Justice Diosdado Peralta.
Okay, I thank the Manila Bulletin for inviting me in today's forum. It's a rare honor to be your speaker in this forum today. One of the novel features of the 1987 Constitution of the Philippines is that its Article 2, Section 16 affirms our right as a people to balance and healthful ecology, providing that states shall protect and advance the right of the people to a balanced and healthful ecology in accordance with the rhythm and harmony of nature. In the landmark 1993 case of Poposa versus Factura, the Supreme Court explained that this right may be more important than any other right found in the Bill of Rights. This is because such a right belongs to a different category of rights altogether, for it concerns nothing less than self-preservation and self-perpetuation, the advancement of which may even be said to predate all governments and constitutions. As a matter of fact, these basic rights need not even be written in the Constitution, for they are assumed to exist from the inception of mankind. The Supreme Court in this case had the occasion to discuss the concept of intergenerational responsibility. It explained that the right to a balanced and healthful ecology carries with it the correlative duty to refrain from impairing the environment. It thus said, the minors opposed case, however, is not the first time that our Supreme Court recognized the right of future generations. Predating the 1987 Constitution is the Administrative Code of 1987, promulgated by President Aquino, which provides that the state shall ensure, for the benefit of the Filipino people, the full exploration and development, as well as the judicious disposition, utilization, management, renewal, and conservation of the country's forests, mineral, land, waters, fisheries, wildlife, offshore areas, and other natural resources, consistent with the necessity of maintaining a sound ecological balance and protecting and enhancing the quality of the environment, the objective of making the exploration, development, and utilization of such natural resources equitably accessible to the different segments of the present as well as future generations. In the 1970s, former President Ferdinand E. Marcos initiated environmental legislation when environmental issues merged as a global concern. He promulgated PD 91151, or Philippine Environmental Policy, which provided the blueprint for National Blueprint for Environmental Protection, and PD 91152, or the Philippine Environment Code, which contained general principles dealing with the major environmental and natural resource concerns of the Philippines. Since then, our Congress has produced a number of environmental laws. Among these laws are the Toxic Substances and Hazardous and Nuclear Waste Control Act of 1990, the National Integrated Protected Areas System Act of 1992, the Philippine Mining Act of 1995, the Animal Welfare Act of 1998, the Philippine Fisheries Codes of 1998, the Philippine Clear Act of 1999, the Ecological Solid Waste Management Act of 2000, and the Philippine Clean Water Act of 2004. Furthermore, the Local Government Code of 1991 empowers local governments to enact measures to protect the environment. In 1997 case of Tano versus Socrates, city and provincial ordinances protecting fish and corals were challenged on various constitutional grounds. The Supreme Court set aside several objections to the ordinances and pointed out that many provisions of the local government code provide the legal basis for their enactment. The court held essentially that they were valid police power measures under the General Welfare Clause, adding that Section 5, Paragraph C of the Code mandates that the general welfare provisions of the LGC shall be liberally interpreted to give more powers to the local government units in accelerating economic development and upgrading the quality of life for the people of the community. The Supreme Court also emphasized that local legislative councils are directed to enact ordinances for the general welfare of the municipality and its inhabitants, which shall include, inter alia, ordinances that protect the environment and impose appropriate penalties for acts which endanger the environment, such as dynamite fishing and other forms of destructive fishing, and such other activities which result in pollution, acceleration of eutrophication of rivers and lakes, or of ecological imbalance. When I was appointed to the Supreme Court as an Associate Justice in 2009, I was given the opportunity to become a member of the subcommittee that was tasked to craft the rules of procedure for environmental cases. The court, through the leadership of the Chief Justice, Renato Espuno, recognized the imminent and mounting threat of climate change, as well as the need to protect our environment through a set of procedural rules that would guide pertinent government agencies, policy makers, and the courts in promoting and protecting the constitutional right of Filipinos to a healthy environment. This was likewise an offshoot of the court's decision in 2008 case of Metro Manila Development Authority versus concerned residents of Manila Bay, wherein Supreme Court ruled that the cleaning and rehabilitation of Manila Bay could be compelled through a continuing mandamus. The court held that the MDA is duty-bound to comply with Section 41 of Republic Act Number 9003 or the Ecological Solid Waste Management Act, which prescribes the minimum criteria for the establishment of sanitary landfills, and Section 42, which provides the minimum operating requirements that each site operator shall maintain in the operation of a sanitary landfill. Based on their charters, the court said that it is clear that the pertinent government agencies are also mandated to perform certain functions relating directly or indirectly to the cleanup, rehabilitation, protection, and preservation of the Manila Bay. The promulgation of the rules of procedure for environmental cases in 2010, considered to have been the first of its kind in the world to facilitate and expedite the resolution of cases concerning the environment, served as a significant catalyst in the support of far-reaching reforms in environmental litigation and protection. Among the salient features of the said rules are the provisions on citizen suits, consent decree, environmental protection order, the writ of kalikasan, the writ of continuing mandamus, strategic lawsuits against public participation, and the precautionary principle. The fifth year on citizen suits relaxes the requirement for standing to sue for all complaints seeking to enforce environmental laws, in recognition of the reality that citizen suits have been successful in pressing the government and its agencies to act on its duty to protect and preserve the environment. Echoing the doctrine first enunciated in the Oposa case, the rules enable litigants to file their cases, enforcing environmental rights as citizen suits, which allowed deferred of payment of filing fees until after the judgment. Another feature of the rule is the consent decree, which was touted as innovative way to resolve environmental cases. Consent decree permitted the entering into a compromise agreement between the two parties in environmental litigation over issues that would normally be litigated in the court and other matters that may not necessarily be of issue in court. An environmental protection order, on the other hand, refers to an order issued by the court directing or enjoining any person or governmental agency to perform or desist from performing an act in order to protect, preserve, and rehabilitate the environment. It integrates both prohibitive and mandatory reliefs in order to appropriately address the factual circumstances surrounding the case. This remedial measure can also be prayed for in the writs of kalikasan and continuing mandamus. Another remedy provided for in the rules is the writ of kalikasan, which contains a particular set of remedies which may be availed of individually or cumulatively. The writ of kalikasan is immediate in nature. It is available to a natural or juridical person, entity authorized by law, people's organization, non-government organization, or any accredited public interest group on behalf of persons whose constitutional right to a balanced and healthful ecology is violated or threatened by an unlawful act or omission involving environmental damage of such magnitude as to prejudice the life, health, or property of inhabitants in two or more cities or provinces. The provision on the writ of continuing mandamus, on the other hand, is made available to compel the performance of an act specifically enjoined by the law. Through it, the court retains jurisdiction after a judgment so as to guarantee the successful implementation of the reliefs it has ordered. The court may thus compel the submission of compliance reports from the subject government agencies, as well as avail of other means to monitor compliance with its decision. Suffice it to say, the writ of continuum mandamus integrates the Supreme Court's ruling in concerned residents of Manila Bay case and the existing rule on the issuance of writ of mandamus. The provision on a strategic lawsuit against public participation or SLAP suit provide a defense for those enforcing the environmental rights. SLAP suits refer to an action, whether civil, criminal, or administrative, brought against any person, institution, or any government agency, or local government unit, or its officials and employees with intent to harass, vex, exert undue pressure, or stifle any legal recourse that such person, institution, or government agency has taken or may take in the enforcement of environmental laws, protection of the environment, or assertion of environmental rights. SLAP suits are meant to harass, prevent, or stifle any legal recourse or any person, including the government, from enforcing environmental laws or asserting environmental rights. Lastly, the rules provide for the adoption of the precautionary principle, through which the court may be allowed to construe a set of facts as warranting either judicial action or inaction with the goal of preserving and protecting the environment. The rules of procedure for environmental cases expectedly and necessarily pave the way for an abundance of litigation involving lawsuits. This was, in my opinion, a natural outcome of the positive transformation of the people's attitude and mindset towards environmental legislation, enforcement, prosecution, and adjudication. Among the important cases decided by the court following the promulgation of the rules is Boracay Foundation versus Province of Aklan, a 2012 case involving the province reclamation of forestry land and construction of a terminal and port in Katiklan on Boracay Island. Following allegations that the reclamation violated procedures for the conduct of environmental impact assessment, the Supreme Court ordered the Department of Environment and Natural Resources to review the province environmental compliance certificate application, particularly as regards the project's classification and impact on the environment. The province was ordered to cooperate with this review as well as to secure the approval of the affected barangay and municipal councils and conduct proper consultations with the sector concerned. In 2015 case of International Service for the Acquisition of Agri-Biotech Application Incorporated versus Greenpeace, the court had the opportunity to tackle the issue of generic engineering and its impact on the environment. Greenpeace and the other respondents sought to restrain the field trials of BT Talong, a genetically modified eggplant, claiming that these activities violated their right to a healthy environment. It deserves mention that prior to its resolution of the case, the Supreme Court issued in 2012 a writ of kalikasan directing the Environmental Management Bureau, the Bureau of Plant Industry, the Fertilizer and Pesticide Authority, the UP Los Baños Foundation Incorporated, and the International Service for the Acquisition Agri Biotech Applications to answer the petition for Greenpeace and other complainants before allowing the release into the environment of genetically modified eggplant. It said that the more prudent course was to immediately enjoin BT Talong field trials and the approval of its propagation until the said agencies shall have performed their mandates to implement the NBF. The next year, however, the court, acting on the motions for reconsideration filed by BT Talong proponents, reversed its error ruling and affirmed the mootness of the case as no commercial propagation of product took place and the research on it never went beyond the field trial phase. The 2020 case of Metro Manila Development Authority and concerned residents of Manila Bay involved a motion to intervene filed by Akbayan Citizens Action Party in 2008 decision of the court involving the same parties for the purpose of holding liable for contumacy the DNR on the ground that each installation of an artificial white beach on a small strip of the Manila Bay was a violation of the writ of continuing mandamus for the sustained cleanup and maintenance of the subject bay and its waters. The court held that the specific directive to the ENR and the other concerned agencies, departments, was simply to clean the waters of the Manila Bay and perform maintenance measures to keep it within the legal standards of cleanliness fit for recreation. It added that the installation of the artificial white beach was not an allied or related activity sanctioned by the writ, proceeding as it did from DNR's own beach nourishment program. Thus, the same could hardly be objectively measured as a deviation from the government's mandate as defined in the writ of continuing mandamus. The Supreme Court stressed that it may, on its own, without need of any petition, cite any of the concerned agencies in contempt for any determined violation of the continuing mandamus. However, in this case, the court did not find any such violation amidst the quarterly reports submitted by concerned agencies and the on-site ocular inspection conducted by the Manila Bay Advisory Committee, of which I was the chairperson. Given this, the court deemed it proper in the case to stay its disciplining hand. In the field of labor relations, I've had the opportunity to draft for the Supreme Court as ponente several of the decisions involving noteworthy developments in the field of labor law. In 2018 case of St. Paul College Pasig versus Mancol and Valera, the issue involved was whether two preschool teachers who underwent operation for scoliosis and fertility treatment overseas, respectively, were constructively dismissed by their employer school. The Supreme Court ruled that St. Paul College, Pasig, failed to discharge its burden of proving the existence of elements of abandonment of work. It held that it was clear that petitioners employed means whereby the respondents were intentionally placed in situations that resulted in their being coerced into severing their ties with the same petitioners, thus resulting in constructive dismissal. An employee is considered to be constructively dismissed from service if an act of clear discrimination, insensibility, or disdain by an employer has become so unbearable to the employee as to leave him or her with no option but to forego with his or her continued employment. In LBC Express versus Palco, a 2020 case, the court said that the employer's failure to promptly act on respondent's sexual harassment complaint reinforced the hostile environment created by its employee, as the delay on its part showed insensibility and indifference for its employees' security and welfare. The court rejected the employer's justification that the employee's case was difficult to decide due to the absence of bruises of witnesses. ruling that this statement and attitude had the effect of discouraging employees from reporting sexual harassment incidents. This amounts to an indifference on the part of the employer and further creates an environment where employees become reluctant on coming forward with their horrific ordeal. What I would like to see is that a law or even as a law, voluntarism probably, no? Or some steps to make ESG, sustainability of ESG, not only applicable to those publicly listed companies, but also to other companies which are not public listed. My experience in the ICTSI is that it is sustained, no? Very much it's ESG. And I would like to see also companies that are not publicly listed, no? Following also the steps taken and or then taken by those public companies insofar as sustainability is concerned. Thank you very much and mabuhay ang Manila Bulletin, mabuhay ang ICTSI, mabuhay Pilipinas.
Thank you very much, Chief Justice Diosdado Peralta. It is now time for our question and answer. And my first question, sir, would be, it's often said that the Philippine laws are in place and the judiciary has done its work. But the problem lies in the consistent implementation and enforcement of the laws. Would you like to comment?
You may be correct on that. You may be correct on that assumption that indeed there is failure in the implementation of our laws and also rules already promulgated by the Supreme Court. What we need probably is to improve on the enforcement of our environmental laws and rules, and probably increase the number of enforcers because we have a lot of forests. Our shoreline is very long. We have a lot of waters. We have a lot of flowers, trees, surrounding us. So I think we need more people to enforce our laws, and it is high time that private citizens should become volunteers in helping the government in enforcing our laws.
With the growing danger of climate risk, should environmental laws even be further strengthened, or do we just need heavier penalties for violators, sir?
As I've been reviewing our laws and our rules, we have already sufficient laws, both national laws and municipal laws. I'm referring to the provincial, municipal, and city ordinances. We have so many, to my count, I think it's already more than 100. And we have also the rules promulgated by the Supreme Court, the rules on procedure for environmental law. The penalties are there. Only that, as I said a while ago, there may be lack of enforcers to enforce the laws, and then probably we increase also the number of prosecutors to prosecute these cases. Especially most of these cases are filed in the provinces, the far from places where probably we do not have sufficient enforcers and fiscals to prosecute all these cases. There is no need to come up with heavier penalties, more than sufficient.
Moving to the subject of labor laws, do you think that the laws have kept up with the times, recognizing, of course, for example, gender diversity or the labor practices such as endo that we see so prevalent today?
So it's so far as gender sensitivity is concerned. I come from the judiciary, and you'll be surprised that there are now a lot of lady judges, more than the male judges, being appointed and being considered for the position of judges and justices in the Philippine judiciary. Now, as far as your end is concerned, I think there should be balance between the rights of the employer and the employees. I agree that we have to review all these endos, but we have also to take into consideration the nature of the employment of the employees, because you cannot just regular all the employees just because they want to be regular. We have to respect that there is what we call a probationary period, where where the employers will determine if that employee can become regular. We have also the project employees, where it is for a specific project. And we have also decisional employees, where they only work during the time when the product of the company has an increase their activity. All of this should likewise be respected. But at the same time, the employer should also recognize the rights of the employees. They cannot just disregard also a good performance and then say that they cannot be regular because because the 6-month period has already expired. So they will just expire although the employee deserves to be regular. So they have also to respect. So there should be a balance between the rights of the employers and the rights of the employees.
And coming out of the health crisis in the last 2 years, how would you objectively grade the social and governance aspect of ESG so far as ICTSI is concerned?
Well, modesty aside, because I'm connected with ICTS, I think among all the private companies, I would say that ICTS was one of the big companies that performed very well. It has introduced the drive-through vaccination. It has allowed the public to have a free vaccination. It has allowed one of the, not the most beautiful casino hotel in the country, the Solar Hotel, where people could be vaccinated inside the hotel. And I think ICTSI was one of the first companies that imported the vaccines, no? And the best vaccine in the public at that time was the Moderna.
And we know that ICTSI is operating 34 terminals over 20 countries all over the world. It's spread out to 20 countries all over the world. Are there instances when prevailing laws of certain countries would conflict, for example, with ICTSI's advocacy and sustainability practices?
I cannot think of any issue on that issue. What I can say is that we have not yet been confronted with such an issue. So I think there is no issue there as of the moment.
You also mentioned something about laws that have to do with environment and indigenous tribes. Is there anything that you would like to add to that?
There was one case in the Supreme Court where we were confronted with an issue about illegal logging, no? And the issue then was that the indigenous people, some of them cut indigenous trees, no? When we speak of indigenous trees, these are the protected trees. However, under the law, when indigenous trees are cut in their domain, no? In their domain, and those trees are used to build their house or comfort rooms, then they are not criminally liable because it is within their domain and then used for that purpose. But if the cutting is done by a company, no, that has been involved in illegal logging, then these indigenous people should not be exempted from criminal liability because they are cooperating with these illegal loggers. I'll give you an example. No? Supposing a logging company use the indigenous people in cutting indigenous trees, but these trees are not actually used for their house or shelter, but instead they are brought down from the mountains and then sold to the public, then they should be penalized for it. No, so I would like to see a law to that effect, that if, however, the indigenous people use the trees, no, or cut the trees for the interest of a private company, then all of them shall also be liable as having participated in the cutting of indigenous trees.
Thank you very much, Chief Justice Diosdado Peralta, for taking us on an incisive look, not only into ICTSI's sustainability advocacies, but also on the intricate governance system in our country.